In this lesson, we will finish with the step-by-step analysis about the legal process for investigations and asset freezing. We will start the second part with the criminal investigation. Criminal investigations are triggered when willful or egregious violations are suspected, with referrals to the DOJ, FBI, or HSI in the US, the NCASFO, or CPS in the UK, and national prosecutors in the EU. Investigative tools include search warrants, grand jury subpoenas, mutual legal assistance treaties, LATs for cross-border evidence gathering, and wiretaps. In the US, key statutes include the International Emergency Economic Powers Act, EPA, Export Control Reform Act, ECRA, and International Traffic in Arms Regulations, ITAR, under the Arms Export Control Act, EECA. The statute of limitations is generally 5 years for ECRA violations, but for IEPA and TWI violations after April 24, 2019, it is 10 years. In the UK, the Sanctions and Anti-Money Laundering Act 2018 SAMLA governs criminal enforcement, with no general limitation period for indictable offences. The EU's Directive 2024/1226 harmonizes criminal sanctions, requiring a minimum statute of limitations of 3 years, with many member states applying 5 years. The burden of proof is beyond a reasonable doubt for criminal cases and preponderance of the evidence, or equivalent for civil cases. Notable prosecutions have resulted in significant fines and, in some cases, imprisonment. Next stage of the sanctions and export control enforcement process is resolution. Resolution of sanctions and export control enforcement cases can take several forms, including monetary penalties, civil settlements, deferred prosecution agreements, DPAs, non-prosecution agreements, NPAs, corporate monitorships, compliance program enhancements, clawback provisions, and criminal convictions. In the US, DPAs are contractual arrangements with the DOJ or other agencies, allowing prosecution to be deferred if the defendant fulfills obligations such as paying fines, cooperating, and implementing compliance enhancements. In the UK, DPAs under the Crime and Courts Act 2013 are available only to organizations and require judicial approval to ensure fairness and proportionality. Monitorships may be imposed to oversee compliance improvements, and clawback provisions are increasingly used to recoup bonuses from executives involved in misconduct. Notable cases include BNP Paribas's $8.09 billion settlement, Danske Bank's $2 billion fine US, and HSBC's $1.09 billion DPA US, each involving significant compliance reforms, and, in some cases, criminal convictions. Factors influencing resolution outcomes include the degree of cooperation, remediation efforts, and recidivism. The last stage of the sanctions and export control enforcement process is the asset freezing. Asset freezing is initiated upon the designation or listing of an individual or entity on the OFAC SDN list, USI Consolidated List, UK, or EU Council listings. The legal basis for freezing includes the International Emergency Economic Powers Act, EPA in the US, the Sanctions and Anti-Money Laundering Act 2018 in the UK, and EU Council Regulations TU Art 29 FU T FU Art 215. Once designated, all property and interest in property within the relevant jurisdiction must be immediately frozen, with reporting obligations requiring notification to authorities within 10 business days for OFAC as soon as practicable for UFSI, and prompt notification to national competent authorities in the EU. Procedural safeguards include the right to challenge designation, submit delisting petitions, and seek judicial review, OFAC administrative reconsideration, ministerial review in the UK, and review by the EU General Court. Humanitarian general and specific licenses or carve-outs are available to permit certain transactions for basic needs or humanitarian purposes. Ongoing monitoring and cross-border coordination, such as the OFAC Memorandum of Understanding MOU signed in 2024, ensure effective enforcement and information sharing, particularly in complex, multinational cases. The legal process for sanctions and export control investigations and asset freezing is a multi-staged framework ensuring compliance and accountability. It begins with detection and referral via alerts, whistleblowers, or reports, followed by preliminary assessments with due diligence and risk scoring. Administrative investigations gather evidence, while civil investigations assess liability, applying strict or willful negligence standards. Criminal investigations address egregious cases using subpoenas and MATs. Asset freezing occurs upon designation with safeguards like delisting petitions and judicial reviews. International cooperation ensures coordination in enforcement efforts.